From this episode, you'll learn about HMRC's Alternative Dispute Resolution process so that you can consider using this to help solve your client's disputes with HMRC. But is it a worthwhile process or is it a waste of time? Our expert guest, Bento, answers this question for us. She says what ADR is, when it can and can't be used, what to expect from the process, her experiences of engaging in ADR for clients, when she recommends using it, and also some tips to increase the chances of success should you engage in ADR. You're listening to episode 110 of the Tax Professionals podcast, the podcast that helps tax professionals with their tax careers.
Welcome to the Tax Professionals podcast, the podcast dedicated to helping you improve your tax career. Here's your host, Jack Bonehill.
Hi everyone, and welcome to this episode. As you heard just now, this episode is all about ADR, with our guest for this episode, Bento. Barbara is Head of Tax Investigations and Dispute Resolution at Buzzacott. She deals with complex voluntary disclosures to HMRC and tax investigations such as Code of Practice 9 and cross-tax inquiries. Barbara is a fully accredited CEDA accredited mediator. She is one of a small handful of tax investigations and dispute resolution specialists that actually has this. She's also ACCA qualified and she won Best Tax Investigations Team 3 times whilst at 3 different firms. I've known about ADR for some time, and for the first time last year I started going through the process with a client with just over £1 million of liability. The client was destined to go to tribunal and it was a latch-dist attempt to avoid that. The HMRC officer for this case was difficult throughout the entire inquiry, which is really why we ended up in this situation with a £1 million liability in the first place. And I felt that a mediator, which is present as part of the ADR process, would help us to resolve the dispute. I knew that we weren't guaranteed to get the outcome that we wanted, but I was optimistic. We sat down with HMRC in the ADR meeting, and in response to our questions, where we were looking for some clarity, all the HMRC officer could do was read from past correspondence that they'd sent to us, and basically they provided us with no new information. They could not clarify for us, despite this being one of the agreed aims for using ADR in this circumstance. And after about 6 hours in, we found out that there was actually no HMRC decision maker present in the meeting, although there should have been, and we'd previously been told that there would be. And I was totally miffed. There was 6+ hours of time wasted for each of the 3 people at my client that were present in that meeting, same for me and for another member of my team, and thousands of pounds of my client's money was wasted. ADR had failed us. But was this a one-off experience or the norm? Was my experience just an exception? You'll find out the answer to that question in this episode, along with what ADR is, when it can and can't be used, what to expect from the process, Barbara's experiences of engaging in ADR for clients, when she recommends using it, and also some tips to increase the chances of ADR being successful for you should you use it. Rough timings for each section of the episode can be found in your podcast player of choice, or by heading on over to the show notes for this episode at thetaxprofessionalspodcast.com/TTPP110. When you start delegating tax work, usually around manager level, you'll probably experience challenges, and part of this will be you could be a better delegator. And part of that will be how good the person that you're delegating to is, and the better they are, the smoother your delegation ride will be. My masterclasses are created purely for tax professionals and are designed to improve the skill level of your tax staff in crucial areas for being an advisor, allowing you to delegate more easily, giving you more time back, reducing stress and burnout. If you like the sound of this, then you can get in touch with me and we can arrange a chat where I can share more about how I can help you and your tax team. You can find me on LinkedIn by searching for Jack Bonehill, or you can send me an email at jack@thetaxprofessionalspodcast.com. Both of these contact details are in the show notes for this episode at thetaxprofessionalspodcast.com/TTPP110. I've been using Kroner's online tax resources for years now. It's almost always my starting point whenever I need to check on some tax rule, legislation, guidance and case law. And to all listeners that work in tax, Kroner is offering a free 1-month trial. The link to get this set up is in the show notes at thetaxprofessionalspodcast.com/TTPP110. Without further ado, let's get to the episode. Barbara, just to start us off, could you tell us a little bit about you and your tax career?
Sure. So first of all, obviously, good morning to your listeners, and thanks again for the invite, Jack, to speak about something that I'm very passionate about, which is, with mediation in the context of tax investigations. So as your listeners may notice, and she says with sarcasm, I wasn't born in the UK. So I'm from Madeira Island in Portugal, and I moved to London 16 years ago. I started my career in audit, actually. I did tax and accounting at university. But then I decided to move to London. I've always been driven, and and at the time, Portugal did not feel like the right place to thrive career-wise. And as I was working in finance, I wanted to be in one of the biggest financial hubs at the time. And for me, that was like either London or New York. The London was easier and closer to home. So whilst I was still living in Portugal, I was applying for jobs online. But then obviously I soon realized that if I wanted to increase my chances of getting a job in London, especially because at the time when I was applying for jobs, there were lots of people being made redundant in London because we're talking about 2008 when the credit crunch happened. So I had to make a bold move if I wanted to get a job here and have a successful career. So I've decided to quit my job back home and, fair to say, a very comfortable life, and moved to London. It wasn't easy to start with, but I guess the universe compensates the brave. So within 2 months, I believe, of being in London, I was offered a position at a private client firm. So I actually started, my background is in private clients. But then when I was working in private clients, I was lucky to have some exposure to tax investigations. And very quickly, I realized that tax investigations suited my personality better. I don't know, in my view, and with all, due respect to people who work in private clients, but in my view, is like tax investigations, it's more dynamic. It involves a lot of problems solving, the way you help people. It's, it's just different. And I found it just like more rewarding. So I decided to go into a tax investigations role full time. And in the last 15 years, I've worked for, bigger firms, tax boutique and mid-tier firms. And I can honestly say that it is at the mid-tier firms where I've always felt more valued, should I say, and where I always felt that I could just be myself. So I joined Buzzcott, a top 25 accountancy firm based in London 6 years ago, and I joined as a senior manager. I've learned a lot and developed a lot in these last 6 years, which ultimately resulted in me being promoted as the head of the tax investigations team last October. In a nutshell, that is it.
Yeah. So actually, you've never worked for HMRC, have you?
No.
Yeah,
No.
because I always think most tax investigations people start in HMRC and then
Absolutely
move out. But you're actually the second person I spoke to this month that's made success of that role and has never worked for HMRC. So it's possible.
Yeah, I don't have HMRC on my CV, but then obviously we'll get into it. But that's why it makes, that's why it's interesting when I get to co-mediate with HMRC at ADR meetings. But we'll get into that.
Yeah. I mean, the reason actually that I reached out to you as well is that you're one of the only people that I could see anyway that work in tax investigations that has that mediator qualification or certificate. I can't remember exactly what
it's CEDA. It's CEDA. So CEDA qualification. I think definitely there are a few more people in tax investigations who hold that qualification. Maybe, there are a few more people who I'm aware. But I'm glad you found me, Jack, and I'm glad we're having a conversation today.
Yeah. So as you kind of alluded to already then, the topic of our chat today is going to be ADR, Alternative Dispute Resolution, which I've actually experienced one time myself for a client. And I'll talk about that a little bit more later. But can you just tell us exactly what ADR is and give us a bit of an overview of it?
Sure. So as the name says, ADR, it's an alternative method to resolve disputes with HMRC using mediation skills. So it is proven to help resolve disputes with HMRC, especially on occasions where matters have become drawn out. So it allows parties, HMRC and the taxpayer, supported by their agent, to air their concerns, grievance, before an independent facilitator, mediator, and then hopefully move to a negotiated settlement and avoiding the stress and the formalities of litigation and tribunal.
So the one thing with ADR that I've always been a bit unsure of, I suppose. I think this is probably the most unclear bit, is what actually classes as a dispute, because does disagreeing about something very early on in the inquiry class as a dispute, or does it need to get to, say, like an appeal stage where, you've actually lodged something with a tribunal?
Absolutely. That's a good question. And I've had a number of people, like potential clients, even like colleagues in the industry asking me the same question. But a dispute, you don't need a decision to go into ADR. For example, HMRC doesn't need to make a decision for you to go into ADR. So a dispute is every time you disagree with the HMRC officer, it's every time you disagree with the HMRC officer dealing with your case about the reason why they've asked you to do something, or, for example, their point of view about your tax liability. So you don't need an appealable decision to go into ADR. You can go into ADR at any stage of an inquiry.
Yeah, which is good to know, because I actually think probably where ADR will be most useful is like very early on in the inquiry, before it gets to a point where both parties are basically annoyed with each other and they can't resolve something.
Yeah, at times, that could be the case. Say, for example, like, when you work in tax investigations for some time, you get to know some of the inspectors. So, for example, like in our work, every time we have a potential client, we ask for a copy of the HMRC's letter. We look at the letter, and there are some names that we go into, okay, this is going to be hard work, and we probably need to go into ADR. So yeah, on occasion, it's probably like, there's not such a thing as, actually, no, there is a right time to go into ADR. And sometimes that right time could be at the beginning of the investigation for whatever reason. For example, because you don't trust or that particular officer, or because of the issues are just too complex, or because based on previous experiences in similar cases, it's going to be difficult to agree a position, during the inquiry process. And you do need a mediator. You do need to have a meeting with HMRC where the decision maker is there. So that could happen at the beginning, or it can happen, later on. You should always look at a case on its own merits and see, like, when is the right time to go into ADR. And there's no set rules in terms of like when you should go into mediation.
Yeah, no, that makes sense. So, from the point then that someone basically wants to use ADR, what does the process look like from there, I suppose, to the point where ADR's finished?
Okay. Right. So in terms of the process, there's an application process, which can be done over the phone or online. Usually, it's done online. And on the form, the online form, the applicant needs to give details of the disputes and, well, obviously their agent, and why they believe ADR is a suitable way to resolve the disputes. So the reasons why they believe ADRs are, and even saying, like, we've tried to agree the position previously, it didn't work, and we believe that ADR is the best way to settle the case. Obviously, ADR is not a statutory process, and HMRC does reserve the right to reject applications if they consider they're not appropriate for ADR. But any decision to reject an application must be agreed by a panel at HMRC. The panel is made up of HMRC employees, but also independent tax professionals, and also the head of ADR at HMRC. Then a decision, so an application is made, and HMRC should be making a decision within 30 days of application. Something that is important to note is, whereas like usually it's the taxpayer who applies for ADR, sometimes HMRC and the officer dealing with the inquiry may suggest ADR. So if you have a situation, because, for example, the taxpayer is an unrepresented taxpayer and they're not aware of ADR, or for another reason. So if HMRC obviously is suggesting ADR, it's very likely that it will be accepted. It's important to note that. So, and once accepted into ADR, HMRC's aim is to have the ADR meeting within 90 days. So the aim is to get everything resolved. That doesn't necessarily mean settled, but to get everything resolved within 120 days. And according with HMRC's data, 90% of the cases are indeed resolved within 120 days. As I said, that doesn't mean full settlements or settlements, but that's what their figures show, and that is the aim. It doesn't always happen. Obviously, it's only 90% of the cases that are resolved with 120 days. But so that's a kind of like time when a client asks you, for example, how long would the process take? It's safe to say that it should take at least 120 days.
Yeah, that
Then
makes sense.
Then a mediator is appointed, and he or she will be contacting the parties to agree the next steps. Usually involves agreeing the timeframes, so the date of the ADR meeting, whether or not there's need for pre-mediation meetings, the attendees from both sides, the date in which opening statements should be exchanged. In terms of the exchange of the opening statements, for example, there's no formal time frame. The HMRC guidance, I think it says a few days before the mediation meeting, ADR meeting. We've had, for example, like mediators, we've dealt with mediators in the past, that some of them, they were quite flexible about it, and where the cases are not particularly complex, they were happy for the statements to be exchanged only a few days before the meeting, and other mediators have insisted for the statements to be exchanged like a month prior to the meeting, which is a bit excessive, but anyway. But in terms of going on, in terms of the process, so as I said, some mediators might invite the parties for pre-mediation meetings. The way where we stand with regards to pre-mediation meetings, obviously, if it is an unrepresented taxpayer, absolutely have a meeting with the mediator so you know what to expect from the day. It probably will be less intimidating if you know what to expect, from the day. But for example, with our clients, we don't tend to agree to those meetings because I'm a mediator myself, so I can explain to the client what he can expect from the day and prepare him. So anyway, but some people might find it helpful. And then on the day, it starts with an opening meeting. So everything has been agreed with the list of attendees and all of that. So you come into mediation and you have a meeting with both parties in attendance. So the mediator typically will go through, his role, what to expect from the day, he will talk about concepts of confidentiality without prejudice, what to expect at the end of mediation, the record of what outcome of the settlement agreement, and so on. And then he will invite the parties to read their opening statements. And then after the reading of opening statements, it depends how the parties are feeling about what they've heard. So if the emotions are high, the mediator should proceed immediately to private meetings. So they can have a private meeting with the mediator, and then the mediator can start his job basically, and then asking questions. How do you feel about that? How do you think that the day will go? Are you prepared to concede here and there? So it depends. So the mediation day, the ADR meeting is really a combination of private and joint meetings. And you can have a number of private, meetings. It just depends how the day goes. You may have a mediation where you only need 2 private meetings, for example. You have others that, you spend more time speaking with the mediator than with the other party. That's not a good sign, but it may happen. So it's hard to tell how, at the outset, how the mediation will go. And then at the end of the day, and sometimes actually, you may have an ADR, for example, that it lasts more than a day. Okay, if both parties are happy for it to last more than a day, it can happen. But if you are able to settle, to reach a settlement on the day, then what will happen? It could be a full settlement or a partial settlement. But whatever is agreed between the parties on the day needs to be recorded on a record of outcome, i.e. the settlement agreement. So the settlement agreement should be, clear. It's usually, it's drafted with the help of, the mediator, but it's what the parties have agreed and is signed by both parties.
Mm-hmm. Yeah. The one thing actually I found quite odd when I went through it myself is I don't really understand why you read the opening statements at the start, because they're written down and everyone can just read. It just felt a bit weird to me.
Well, yeah, I guess, I know what you mean. I guess you have to start, somewhere. And also I think it yes, you have the opening statements in front of you. Everyone had a chance to read them. But I think, when you're reading out loud, say for example, HMRC or the taxpayer or or say for example, usually the agent will read the opening statement on behalf of the client. And sometimes it happens. I noticed this before. Even though your client knows what the position is, and and it's usually feeling very, I don't know, like that feeling that he or she was mistreated or is being mistreated by HMRC. When they just like sitting down and listening to their agent reading the facts, the mediator can is an opportunity for the mediator to pick up on certain body language sort of like signals, and then he can use that and explore that at the private meetings. So I get what you're saying. It's almost as if like, oh yeah, we know this, we already went through this. Well, what's the point? But I think it's still a good thing having the parties to to read the opening statements. It gives time to kind of like for the party to reflect again at that time about in the room and in the joint meeting about what the case is really all about. And then an opportunity for the mediator to kind of like read the room, read the emotions and act on those emotions and body language signals.
That makes sense. I suppose then prior to it being read out, the mediator doesn't really know how each party feels about the facts and the statements, but that gives the mediator an opportunity to get a feel for that. So that does make sense, actually. Are there any situations then where, ADR can't be used? Because it sounds like it can be used in a lot of cases because disputes is very broad and you can use it pretty much for any dispute by the sounds. But are there any situations where it's just not applicable and you can't use it?
Yeah, sure. HMRC actually, lists the situations where it can't be used. So if you go into, the website, it's like, a full list of the circumstances why it can't be used. But just to give you an idea, for example, it can't be used to deal with complaints and disputes about HMRC delays in using information or giving the taxpayer misleading advice. And this is an interesting one. I would imagine lots of taxpayers and their agents would love to have to go into ADR, to go into a room with HMRC to complain about them with a mediator present. But yeah, sadly, she says it can't be used to deal with complaints about HMRC. It can't be used in cases where HMRC criminal investigators are already dealing with the case, debt recovery or payment issues, disputes about tax credits, POA coding notices, for example. But again, why would you go into a DR for POA coding notice? Other stuff will include APNs and forward notices, for example. Pinch and nothing on APNs and forward notices makes sense because, there's no right of appeal. And other stuff would include pension liberation schemes, and there's a few others. But again, I think, as you said, as you said, like HMRC makes it very clear where it can't be used, not so clear where perhaps it can, because obviously when they say it can be used as a dispute, but then obviously there's some people are not quite sure what it means, a dispute with HMRC. But in terms of like where it can't be used, there's a full list of circumstances on HMRC's website.
Yeah, which is helpful, isn't it? I mean, the one that you kind of pointed out as being unusual that's in there is when they've given like incorrect information or advice. Because that's almost like the ideal situation to be in a dispute, isn't it?
Absolutely. I would love to mediate a case.
Yeah.
Where there's some issues about, one party giving, in this case was the HMRC giving misleading advice. But that's me.
Yeah. Well, I think it'll be fun as well. I mean, to be fair, like you, I do absolutely really enjoy dealing with HMRC, and particularly I suppose where it gets difficult, because I almost see it as a bit like an argument. And as a kid, I loved having pointless arguments with people. So it's almost like a chance to do that. Obviously, I approach it much more professionally than that when I'm doing it. But
same.
Although in my head, I'm probably thinking, I'd love to say this outrageous thing that I'm thinking.
Yeah, I know what you mean. Well, one has to be a bit more diplomatic when it comes to, like a professional environment.
Yeah, exactly. I always have to remind myself what's going to get us to the end goal that we want, not what's going to be, what do I want to say based on how I'm feeling right now.
Absolutely.
So is ADR actually used that much then in with HMRC disputes? Because I always got the impression that it was kind of there, but not really used that often.
Yeah, I guess it is still, it is used very frequently, but obviously, for example, in terms of like, I have some figures, for you, for example, for 2023-24, it's actually 23-24, according with HMRC's accounts and reports for 23-24, there was about 1,309 applications. But the year 22-23, there was a number of applications was 1,047. So the number is going up. So I would say this suggests that, ADR is still popular. It's still like people are still using ADR. I think there's perhaps not enough awareness about ADR and about the advantages of ADR, which is why I think, it's great having, you having a podcast about, ADR and mediation. But I think, it is still popular. And obviously, ADR assists in dealing with backlog of tribunal cases. So, rather than waiting months and months to get, your case heard at tribunal, it's an alternative to, so ADR is an alternative to litigation. Obviously, it's cheaper, more flexible than tribunal proceedings and all of that. So, I would say it's still popular.
If you want to have a smoother ride when delegating tax work, get time back and become less stressed, and avoid having burnout, then message me to arrange a chat, or I can share with you how I can help you to do this. Through my masterclasses created specifically for tax professionals. The better your tax staff are and important tax skills, the easier your life will become. My contact details are in the show notes for this episode at thetaxprofessionalspodcast.com/TTPP110. And if you want access to a 1-month free trial for using Corona Eye's online tax resources, then head on over to the show notes too for a link where you can get access to this. Back to the episode. So, for you personally then, how many times do you think you've actually gone through ADR then with clients at this point?
A number of cases, but I would say, for example, the cases that, from a personal perspective, that I found more memorable, remarkable, were the cases where I've co-mediated with HMRC. In the last, I think, 6 years, I think since I joined Buzzercourt and since I became a CEDA accredited mediator, I've co-mediated with HMRC about 4 times. But obviously...
When you say co-mediated, what do you mean by that? Do you mean you actually on HMRC side then?
No, Jack, not on HMRC.
No.
So I was appointed. So the times in which I was able to co-mediate a case with HMRC to start were cases where I wasn't involved in the case. Even though it was a Buzzercourt client, I wasn't a caseworker. So I knew nothing about the case. Okay. So I could remain impartial on the day. And you basically what you do, you are just another mediator on the day. Rather than just having HMRC's own mediator, you are there to do the same thing as HMRC mediator will do. Obviously, ADR is an HMRC process, and I need to respect that, of course. But both mediators will work together to achieve the best outcome possible on the day. And it is possible, and perhaps this is something that, some people are not aware. It is possible for a taxpayer to bring their own accredited mediator on the day, or to have them mediating ADR with HMRC on the day.
So basically then, just so I'll get this right then. So when you've worked with ADR, you've almost done 2 different roles. One is where you're not actually acting as a mediator, you're just kind of putting the case forward on behalf of the client as their agent. And the second one is where you're not actually involved in the investigation, except for you're now mediating the ADR process alongside a HMRC mediator. So you probably knew very little upfront in that second case.
Absolutely. That is the case. Absolutely. I will know as much as about the case as HMRC's mediator. And, and also, for example, I remember when I started co-mediating with HMRC, I don't think there was such a thing as like a terms and conditions for external mediators. My first 2 mediators, I didn't have to sign anything. But then HMRC then started asking external mediators to sign the terms and conditions whereby, I am confirming and that I have not been involved. I haven't been previously involved in the case. I know very little, and I will be impartial and objective in a day. And obviously, I would never agree to, and will never suggest to have me as mediator on a case that, I have been involved. So
yeah, well, you're biased at that point, aren't you? So.
Yeah, absolutely, and it wouldn't be the right thing, And then I would expect exactly the same thing from HMRC as well, because let's not forget, HMRC mediators, they are still HMRC employees. They are paid by HMRC. So if they can do it, why is it that, we shouldn't be able to do it as well if the circumstances are exactly the same?
Yeah.
And it's quite interesting because whenever I've co-mediated cases with HMRC, that's probably, say, for example, if we talk about face-to-face mediations, ADR mediations, they will be held, they're usually held here in our offices in London. And we have 3 meeting rooms booked. And I stay in the room the whole day, and I have my colleagues in the other meeting room. And that's probably the only time that, for example, myself and, and my boss, Mark Taylor, is in the office, and we do not talk during the day. It's strange, but we don't. It's very tempting. Sometimes, I'll go out of the meeting room and I could see them there and you think, look, but, we would literally do not talk during the day. We say nothing.
Yeah. Interesting. Yeah. I mean, to be honest, the point they said about the HMRC mediator being a HMRC employee, I almost struggled to get my head around that a bit because it almost felt like they were conflicted straight away and that they were automatically going to be biased somewhat. I mean, the time I went through it, it didn't feel like that an awful lot, but there were a few times where I was like, are you really trying to resolve this dispute, or are you trying to back up HMRC side? And actually the one I went through as well. So I know you said, I think you said that you can actually get settlements done on the day. Not always the case, but you can actually get settlements done on the day. In the case that I did, there was no one with the authority to sign a settlement or to agree anything. Literally nothing could be agreed in the one I did. All that could be done was, I suppose, communicate the misunderstandings and what each side wanted to happen going forward. But then the people that were in that meeting had to then go away and get authorization for the way on how to proceed. And it felt really, well, I don't know whether that was a mistake on HMRC's part or whether ADR is always like that. It sounds like it's not based on what you're saying, but the fact is that no decisions could be made by HMRC in that meeting. I found really, pointless. It made it feel pointless to me, the whole process.
Absolutely. No, I agree. And unfortunately, it does happen sometimes. That's why it's so important to make sure. And again, this is part of the conversations that need to be, had prior to the ADR meeting. It is crucial that the decision makers from both sides are present at the meeting. And you know what? I will be, for example, if I'm in a situation where the ADR meeting, I know it's not always easy, but if next time you go into an ADR meeting, the first question you should be asking is whether the decision maker at HMRC is present. Because, before the ADR meeting takes place, obviously, as I think I was saying earlier, the mediator will agree the list of attendees and all of that. But last minute changes may happen. But you are quite within your rights to say that actually, I don't think this mediator, and have a conversation with the mediator, private conversation with the mediator, and say, I don't believe that this meeting should go ahead today because we'll not be able to agree anything because the decision maker is not here, and postpone the meeting. Because that is very frustrating. We had that, happening previously, I think, in one of our cases, not a case that I co-mediated it's very frustrating.
Yeah, it was. And I mean, I think I'm right in saying this, you can tell me if wrong, but I think if you then say we're not going to proceed with the meeting because there's no decision makers, don't you then have to reapply for ADR to get back to that point and potentially take, say, another 90 days or something to get back in that room with, this time, hopefully, the decision makers with no guarantee again of them being there?
No, I couldn't say, I can't say categorically that you don't have to go through the whole process again. But I don't think you do. And again, I think it would depend, on the mediator. I think the mediator would understand that, that the mistake has been made, by HMRC, especially because, if it is the decision maker in the HMRC side respectively couldn't be bothered to be there on the day, why would the taxpayer would have to go through the whole process, the application process again? I'm not entirely sure, Jack, on that. If you were to postpone the mediation, if you had to go through the whole application process again, but I pretty much, doubt that, you would have to.
Yeah. I think actually, based on what you're saying so far, I think I've just had a really bad experience of ADR, potentially one of the worst cases possible, which it makes sense in some ways because it was to do with VAT. Actually, I don't work with employment tax, so people might be thinking it's odd that I was dealing with that in this case. It's easily explainable, but I won't bore people with the details in this episode. But it was to do with where there was VAT fraud in our client's supply chain. So our client actually hadn't committed frauds, but HMRC were suggesting that someone else in the supply chain did, and that our client should have known of that fact. So it was always going to be a difficult case, I think, anyway. But I felt like the mediator just wanted to get to the point where they could write their like outcome of the ADR meeting. I felt like they were so focused on that and not actually resolving the dispute, and it just made it feel like a bit of a tick box. And then secondly, we didn't find out until about 4 hours in that the people there couldn't actually make a decision on the day without going away and getting it authorised by someone else. So it just left a really bad taste in my mouth about it. So coming into this episode today and speaking to you about it, my view was very much that ADR is pointless. And I always wanted you to convince me that that's not the case, and then it was just a bad experience. And I think I'm already there at this point.
Yeah. Oh, that's good. That's it. Because the thing is, listen, what you're telling me, unfortunately, I've had similar experiences before. Actually, like, recently, I've had a meeting with actually some, colleagues in the tax investigation industry where we actually had someone from HMRC ADR at that meeting, and we were kind of like, voicing, this concern. But what I can also say to you is like, when we had that, particular, meeting, I remember like when we started the meeting, some of the people around the table were like, oh yeah, ADR, it's pointless, it's not worthwhile, the mediators are all biased and so on. By the end of the meeting, I think, I think everyone in the room was feeling a lot more hopeful in terms of and positive about ADR. Because then, again, we're all sharing like our experiences in terms of ADR. And for example, in my personal experience, Jack, obviously I had cases that didn't go as well as, as we hoped for. But in my personal experience, having dealt like, for example, in the last like 6 years, including the cases I've mediated or just was there representing the clients, I don't know, maybe like 10 cases, it was a success. At times it was frustrating, but we've achieved something. Okay, so I would say, like, in terms of like our success, rate, well, success rate. I know this sounds like such a cliche, but it's true. Is 100% success rate, and the way we kind of like our success rate is not like HMRC success rate.
Yeah.
Because HMRC considers partial settlements as a success. So when you look at their figures and they say, oh, yes, ADR has 83% of the success rate, that includes partial settlements, which is still like obviously, a good outcome. But yeah, so hopefully, in my view, it is worthwhile. It's still, a good opportunity to kind of like, try to resolve disputes, even if you don't agree all issues. And even if you want to proceed, say, for example, the tribunal is an opportunity to narrow down some of the issues and to get some clarification in terms of some of the facts. And also maybe it's also a way to assess HMRC's appetite for litigation, for example.
Yeah. When you say partial settlement, then what do you actually mean by that? Does it mean that you haven't resolved all disputes, but you resolved some of them? Yeah. Okay, because obviously sometimes then the resolution isn't actually a settlement per se, is it? It might be that they agreed to, I don't know, deal with the inquiry in a certain way going forward, and that's what you wanted to agree with them.
Yeah, exactly.
Yeah, that makes sense then. So I think I know where you stand, but I'm still going to ask you the question. So where do you stand then on an ADR? Is it worthwhile in your opinion? Is it effective in resolving disputes, or is it a pointless exercise?
Yeah, so in my opinion, it is still worthwhile, but obviously there are a few things that may, or I guess actually I could say, will most definitely increase the chances of success, and those things are things that actually the parties can control. In terms of in which circumstances could be effective. For example, obviously, when HMRC is not listening, if you're dealing with an experienced tax inspector, when there are doubts about the facts, for example, or say, for example, you may have a situation where you've provided HMRC with the evidence, but HMRC just has disputed the evidence that you've provided, or the other way around, HMRC is relying on data that you believe that is incorrect. For example, or HMRC continues to request more and more information, from the taxpayer, which is drawing out proceedings. Now, there's a number of cases where, it could and it should be used.
Yeah. I think you said something way earlier on in this chat. I think it was basically a reference to where some officers are difficult. So do you think it's circumstances then where you have a difficult officer, i.e. that they're not listening to you, that it seems to be like their way or the highway? In those cases, it's usually effective then.
Yeah, for example, because it's in a situation like that, when you're dealing with an inspector that may be difficult, obviously you still have the option of asking to speak with their manager. But they get a bit funny when you ask to speak with their manager, for example.
Yeah.
And their manager might not be the decision maker. So, if you feel like, you're getting nowhere, the ADR absolutely, will be a good way, potentially a good way to resolve the dispute. It will make
Yeah.
it even more interesting if you have like some sort of issue with the inspector on the day of
Yeah.
mediating.
Yeah. So I know you said in your case, and it sounds like you've got 100%
Hmm.
success rate then, which is obviously great. That's not even included the partial settlements, but like, is it 83 or something percent? And you said that is like the success rate that in terms of how
Yeah.
HMRC measure it anyway.
Yes, it is. So I think the figure for 23, 24 was 83% and 80 in 22, 23. But as I said, yeah, it does include partial settlements, which is something that I've learned maybe 2 years ago or so, because before I was, okay, that's pretty good. There's very high success rate, but yeah, it includes partial
Yeah.
settlement. So you might have like 10 disputes, for example, and only one is agreed, and HMRC will count that as a success. So it might not be 83%, but anyway.
Yeah. I wonder whether those numbers are slightly skewed because I think they're probably going to have taken my case as a partial
Oh, yeah.
settlement because
Yeah.
at the end of it, what was agreed was that basically, whilst it was appealed and it was going to tribunal if it wasn't resolved beforehand, they basically agreed to reconsider the
Oh, okay.
situation and
Okay.
well, and they see whether they could get agreement from the decision maker, whether they would reconsider it
Mhm.
anyway, and we could put our case forward. But I remember where we got to was that basically the client could have ended up spending, say, an extra £5,000 for us to then re-put the case together to get it in. So when it was put in front of the decision maker, that they had all the right facts to basically come to a right decision. But we never felt confident that that would happen and that they were just already had their like decision made up because we never actually spoke to any
Mm.
decision makers. We only spoke to people who
Yeah.
the decision makers were speaking to.
Yeah,
But
of
I think
course.
HMRC probably cast that as a partial settlement
Yeah.
then, but I would not have even considered that a partial
Yeah.
settlement. Sure. It was an absolute disaster from my side.
Wow. Yeah. Now I get it. I get it. It's interesting to see what the standards, isn't it?
Yeah.
What HMRC considers a success and what we and our clients would consider success. But yeah,
Yeah.
different standards.
As well, like I know this episode's not about complaints, but I've had the exact same experience with complaints.
It's very like frustrating and to deal with, and then it's just like it's one of those things. Obviously, we as agents sometimes we feel like really bad for our clients, and sometimes we do ask clients if they want to complain and if they want to, and sometimes we put cases forward to get like a compensation for professional costs incurred or compensation for like the anxiety and stress caused and things like that. But sometimes clients are they just had enough and they just say, I just let it go. But then it's just not right.
No.
It's just not right. Yeah, the complaints process. I don't think it really works, and it's something that needs to be looked at. And I think HMRC knows that it needs to be looked at and needs to be taken more seriously.
So what do you think you need then to make ADR go well then? So you mentioned, for example, that you should ask very early on whether there's a decision maker present in the meeting itself. But is there any other things that you think lead to ADR being successful as opposed to unsuccessful?
Yeah, so I think, and I'm not just saying this because I am a mediator, myself, but I think it does make a difference when you have your own mediator there on the day. Because, and again, sometimes, for example, in all ADR meetings I've been, like some of the mediators, HMRC mediators were really, really good, others not so good. So I think you increase the chances of success by appointing a trusted and accredited mediator. I think that helps. Preparation is key. Just as in litigation, preparation is really key for a successful outcome. So it's important that, your client, that you prepare your client in terms of like what to say, what not to say, and you as the agent have a full understanding of the facts. Mindset, is sometimes, people go into mediation and they think like, this is what I want to achieve and I won't settle for anything less. You have to be open-minded. Okay. So if you have to, HMRC and the client taxpayer needs to demonstrate some flexibility. Otherwise, you're not going to achieve anything, or you're going to achieve very little. Obviously, things like set aside sufficient time. As I think I mentioned earlier, ADR meeting can last, 2 hours. We had a case and the mediator was brilliant, I would say. HMRC mediator was really good on that mediation. It lasted like 2.5 hours, and we had other mediations that it lasted a whole day. So make sure that, you don't feel rushed, that, you set aside sufficient time. I know we talked about opening statements, but it is important that you set the tone with your opening statements. You come across like, confident in your opening statements, like the right emotions come through, because the mediator will pick up on those sort of like clues as well. In terms of offers, make realistic offers. And this again goes hand in hand with what I said in terms of like, mindset. Going into a mediation thinking that, you're always right and you don't want to settle for anything less, or asking for something that, HMRC would never agree on, it's not very helpful. So these are some of the tips is just like, obviously take breaks during the day, especially if, if it is a long mediation, and the mediator again should kind of like, notice these things and, invite people to have breaks at the right time. So ensuring that, people take breaks and make the most of like private meetings and, the time that they have, with the mediator. We talked about this as well, but it is hugely important to ensure that the people who are there on the day have authority to make decisions, and ensure that, the decision makers are present at the ADR meeting.
There's a lot that can be done basically then. It's not as easy as it then as just basically turning up to a meeting and having a chat. There's a lot more that needs to go into it to really make it successful.
Yeah, absolutely. Absolutely. Yeah, it's not just another, even though, as I said, like, the process, the ADR process and ADR meetings are supposed to be, an hour, less formal than a tribunal hearing, for example, and a lot more flexible. It's still a process that, you should make the most of it. It's a great opportunity for you to have like, open discussions without prejudice, discussions, with HMRC to kind of like, try to assess what they will prepare to accept and not prepare to accept, with the presence of, a mediator, a facilitator who's there to kind of like, to help parties to reach an agreement. He's not there to judge. He's not there to make decisions. He's not there to, to give his or her opinion. But, it's a really good opportunity to try to to resolve disputes. It's not just another meeting. It's more than that.
Yeah, no, it does sound like it. It sounds like you haven't had like an actual real bad experience then with ADR because you've been successful in all them. But what was like the worst experience that you had then with ADR?
Well, yeah. So I guess you can say that I didn't have a bad experience because we've been successful. But we had situations where, for example, the mediator was, very inexperienced, and, you were kind of, so for example, you were in a situation of like, complete deadlock and you couldn't move past that. And, the mediator was, didn't really, if he hadn't been there, it wouldn't have made much of a difference, for example. And the mediation took a lot longer than it needed to take. We had another situation, for example, I wouldn't say a bad experience, but then it's just things that, really shouldn't happen at ADR. A situation where HMRC decided to bring in more people than necessary and than previously advised. So, for example, I'm trying to remember, and that was a meeting, that was an ADR meeting that I was co-mediating with HMRC. And I remember, so for example, I can't remember exactly how many people were supposed to attend from HMRC side, but I believe it was like 3 people from HMRC side. 2 for direct taxes, 1 indirect taxes. And then from Buzzercode side, you probably had 3 as well. And then on the day of mediation, you had like 5 HMRC inspectors. And I was like, Buzzercode was like, sorry, who are these people? And obviously the mediators were there talking with HMRC. And Buzzercode refused having these extra 2 people. Actually, no, sorry, it was just one person in the meeting. And obviously for the client, it was intimidating because the client, it's like in terms of like, numbers, like having like 5 HMRC officers there to agree, to try to resolve a dispute that, to be honest, it wasn't that complex. It's intimidating and it shouldn't happen really. So that's why it's important to go through the list of attendees and making sure that the people who are at the meeting on the day are the people that you were expecting to be there.
It's
So that was,
ridiculous, isn't it? That's bad on
yeah,
so many levels. Not just because
it
they've
is.
essentially blindsided you before the meeting, but also why do you need that many people there? Like, how many people do you need to
Wait,
change the light bulb? In this case, 5 inspectors. It's just ridiculous.
absolutely, yeah, absolutely. It was ridiculous, waste of time, and actually, that case, they would not the HMRC. I can't remember which office they were from, but not London. So the officer who did not attend the meeting, he travelled from, I can't remember, up north, up down south, can't remember, but he actually stayed. I think the mediation would have taken maybe like that one, like 5 hours or something like that. And he was just like sitting in one of our meeting rooms waiting for it to be done.
Wow.
Honestly, waste of time. Anyway,
Yeah.
so yes, another situation, like situation where we had when the decision maker wasn't there, similar to what you've experienced, Jack. We still managed to narrow down some of the issues, but it wasn't as productive as it could have been. But I think there was some other something, but we had the case as well where, for example, husband and wife were both attending the mediation, and obviously it's never easy talking about tax. And what HMRC was alleging, if they were successful in their allegations, would have a massive impact in the couple, as a family. And then I remember because the emotions were so high, the kind of was obvious disagreements, between husband and wife, and they're kind of arguing there in front of us. So that was a bit of a delicate situation that it happens sometimes. So, but yeah, that's anything. I guess can happen when trying to resolve disputes, and when talking about stuff that can have a massive impact in people's lives and people's businesses. So yeah, that was an emotional one when we had a couple attending, and then they just basically just start arguing and became very emotional, and we had to manage that as well.
Yeah, another dynamic. It
Yeah.
sounds like actually a lot of the ones you've done them are in person as opposed to via Teams. Is that
Mm.
because they've changed the rule now, haven't they? Isn't it
Yeah.
used by default?
Yes, absolutely. So the face-to-face ones that we had were all before, a COVID. So we did have some virtual ADR meetings, and I can say that is not quite the same. Actually, it's a shame that, that now HMRC only in the very exceptional circumstances would HMRC consider to have face-to-face ADR meetings. I think maybe only 5% of the applications, if that much, HMRC would be prepared to have a face-to-face meeting. And that will be because I don't know, there's really exceptional circumstances. Also, for example, the customer, as they call it, the typical space, say, for the hard of hearing, for example, or if they're, if there are concerns about, mental health, perhaps, I don't know, HMRC doesn't actually say when would they consider to have a face-to-face meeting. And I can understand why some people could take advantage of it. But yeah, so in terms of the ADR meetings that I've had in the past was a mix between face-to-face and remote mediations. Obviously, my preference, it is face-to-face ADR meetings. But when you think that HMRC only has about 30 accredited mediators, internal mediators, so it's very hard for 30 mediators to handle how many applications I said were made in
Thousands or something.
23, 24, 1,309. So I can see why HMRC would prefer a virtual ADR meetings, in terms from a cost savings perspective, works, way better, for them. But, in my view, I think face-to-face meetings are, work better, way better.
Yeah, and I agree, and I think I agree with the immediate, I suppose, benefits of doing it on Teams for HMRC. But I think it's short-sighted because if you have to then have, say, 3 meetings because you can't resolve it in one, is that really a better use of time to do it over Teams? Or if then the inquiry ends in a place where it goes to a tribunal, is that really worth it just because it was done over Teams? I think it can have a massive negative effect on the outcome. Personally, I think whenever you're in a dispute with someone, if you're not in the same room as them, it's never going to be the best way to resolve it.
Absolutely. It's just like in, in day-to-day life, if you have a problem with someone, you don't send you don't try to resolve over the phone or over, Zoom. You always say to the other person, let's meet face to face. let's have an open discussion about this situation. It's no different when, resolving tax disputes. And especially like, as I was, the case I mentioned earlier, where you had like, 4 people from HMRC, like 3 people Buzzard side, and then like 2 mediators, like having that number of people, having a virtual meeting when people are talking at the same time, and it makes the mediator's role like, a lot more difficult. And yeah, it's not as effective, in my view. In very like simple, straightforward cases, it could work. But then why would you go into a mediation to deal with a very straightforward, case? But anyway, but yeah, I think in more complex cases and where there are a lot of parties involved, or for example, when you have to go through a lot of evidence, for example, I don't think in virtual meetings is the best way to, to handle it. But anyway,
Yeah.
that's my view, and and so I'm glad it's your view as well.
Yeah, no, I agree. But do you think then it become a lot less effective then with teams being
Well,
face to face?
yeah. So again, because if you look at HMRC's success rate, actually it did drop like 3% from 22 to 23 or something. But, according with their success rate, it doesn't seem that it had an impact, like, the change between like face-to-face to virtual meetings. But I'm a bit cynical when it comes to like, the success rate. And I don't know, I don't think that it works as well. So yeah. That's my view. Maybe I'm just old fashioned. I like to, look people, in the eye and have face to face meetings. And I think that's, it's not COVID anymore. It's so, yeah.
Yeah.
And then perhaps, HMRC, I know there's like, obviously there's a lack of, funding and all of that, but they also need more trained mediators. I think, that would help as well. I know sometimes they use external mediators at times. But yeah, if they had more, for example, trained people, perhaps it wouldn't be so much of an issue in terms of like having face-to-face meetings.
Yeah. So where can people learn more about you then, Barbara, and potentially even get in touch with you?
Yes, so they can find me on LinkedIn. So if they just search the name Barbara Bento, in our company's website, which is www.buzzardcourt.co.uk, and it's Buzzard with 2 Z's and 2 T's.
It turns out then that I did just have a bad experience with ADR. So our conclusion is actually that it is worthwhile to use ADR, so long as the circumstances are appropriate. From what Barbara said, I would say the main circumstance where you should consider using ADR is when you have a difficult HMRC officer that you're clashing with. In such a circumstance, you should enter into ADR early in the inquiry process. If you're thinking about using ADR, consider having support from an experienced ADR professional, as they can help make the process smoother and increase the likelihood of success. Show notes for this episode can be accessed at thetaxprofessionalspodcast.com/TTPP110. Those show notes include all links mentioned throughout this episode, including a link to details of our masterclasses, getting a 3-month trial of Corona Eyes online tax resources, my contact details, and link to Barbara's LinkedIn profile and website. If you enjoyed this episode, you can head on over to thetaxprofessionalspodcast.com/subscribe to sign up for email notifications for all future episodes. Episodes are bi-weekly and are released on Mondays. If you listen to Apple Podcasts or Spotify, I'd really appreciate if you could leave me a rating on those platforms. And if you could and you use Apple Podcasts, it would be even better if you could leave me a review on there. There are links to where you can do this in the show notes. That's it for this episode. I hope you found the episode useful and have taken away some useful points to help you to progress, develop, and improve your tax career. Until next time.